This is AHA Business Radio, creating aha moments for business, by business, and about business, providing opportunities to discover information to help you run your business and guide your decision making. The more you know, the better decisions you make. AHA Business Radio is produced by Allan Hirsh Advisors. For more information, log on to ahabusinessradio.com. To join in tonight's conversation, call 410-481-1300. Now, here's your host for AHA Business Radio, Allan Hirsh.
Good evening. Welcome to tonight's show. My guest in the studio with me tonight is Russell Berger. He's a labor and employment attorney with the firm of Offit Kurman, which is a regional firm in this area. So welcome to the studio, Russell.
Thank you. Thanks for having me.
So, first of all, what motivates you to get up in the morning and go to work?
Well, there's a lot of things, but I think the number one driver for me is, I want to have a relationship with my clients, and I want to be a partner with my clients to help them build their businesses and grow their businesses. And the way I look at my job is I'm an advisor, I'm a partner. I want to help them build whatever it is that they're building.
Sounds great. So, how'd you get started? You're a lawyer, obviously went to law school, but a little bit of your background and how you got into the labor employment law?
Sure. Well, and I think like a lot of lawyers, my DNA probably compelled me to become a lawyer, and I probably had no choice but to become a lawyer. It's just kind of contrarian by nature. But in any event, I went to college, I went to law school right out of college, and I got into the practice of law, and I was doing defense work, and I actually represented a lot of other attorneys that were getting sued for malpractice, and which is a great way for me to start my career, is kind of learning the ropes by seeing what other attorneys had done incorrectly or what they had done.
Well, we do learn a lot of what we do learn from our mistakes, but you were learning from other people's mistakes. Hopefully you weren't making many, but learning from theirs.
Yeah, that's a lot better than learning from my own. So that's kind of where I got my start, and I came over to Offit Kurman about 5 years ago and got into the labor and employment group there, which is a really interesting practice area because no matter what's going on in the world, there will be businesses that will have employees, and as long as businesses have employees, they will have conflicts with their employees, and they'll have risks associated with having employees, and that's really where I come into play.
So then one of the reasons, well, there are a couple of reasons I'm having you on tonight talking about labor and law. 1 month from today, the new Department of Labor standards on overtime pay goes into effect. So can you explain to the listeners what that really is?
Sure. And there's really two main components of what this change in the law is. So to kind of back up a step, there's a federal law called the Fair Labor Standards Act, commonly known as the FLSA, and that's the law that says you have to pay minimum wage to certain non-exempt employees, and you have to pay overtime at a rate of time and a half for their overtime hours.
So you mentioned exempt employees. For the listeners out there, and maybe you'll come to that, but what's an exempt employee? Because that's critical in this discussion.
Right, and it's probably the area where most employers go off the rails on this issue, is you have to make a determination for every employee that you have as to whether or not they're non-exempt, which means they're going to be required to receive the minimum wage, and they're required to receive time and a half for overtime.
So they're really hourly wage. The non-exempt are hourly wage earners predominantly.
Yes. Yeah. I mean, that's a proxy for it.
Right. Because they have to be paid the over. They could be making an annual salary, but if their job description is such, they still have to be paid for the overtime. Just because their salary doesn't make them exempt from the overtime.
Correct. And lots of times we'll have clients that will say, well, I pay this person a salary. Aren't I okay? And the answer to that is maybe, but it depends on what their job actually is and what their duties are. And obviously the flip side to the coin is the exempt employee. And those are people where you don't have to worry about minimum wage. You don't have to worry about overtime premiums. And there's certain tests that will take an employee from non-exempt to exempt. So generally the way I would approach it if a client were asking me to analyze their work staff is I'm going to start with the assumption that everyone's non-exempt. and I'm going to try to find a way to make each employee exempt. Can I satisfy any number of tests? Because we'll talk about a few of them here tonight, but there's 20 of them, and it gets pretty nuanced, and you can really get into the weeds with it. So one of the big areas, and this is what's going to be.
So before you do that, I just want to remind the listeners that I'm talking to Russell Berger of Offit Kurman. If you have any comments, questions, or about the topic, right now we're talking about exempt versus non-exempt employees in the new hourly wage law, give us a call at 410-481-1300. So why don't you go on and talk about that testing? As you said, you want to consider from the beginning that everyone's non-exempt and then find ways to make them exempt so you don't have to pay overtime.
Right. That's the conservative part of me as the lawyer, just assuming we should pay everyone overtime unless we find a good reason not to. And so when you go through that process of looking at the different tests to qualify for an exemption, there are 3 exemptions that get lumped together typically, and they're called the white-collar exemptions. And those 3 exemptions are administrative, executive, and professional. And those 3 tests, those 3 exemptions, require both a salary component and a job duties component. So, for example, for me, I'm a lawyer. I qualify for the professional exemption. My wife is in human resources because that's kind of a back office function that most businesses have. She qualifies for the administrative exemption.
Now, administrative, there are also, as I remember from my days as a business owner, there is gray areas in the administrative as well. Yeah, I mean, a secretary or a clerk or someone like that, a bookkeeper who's actually in the ministry, depending on how you define, you consider them in the administration of the business, they might not qualify. Right.
And to be clear, there's certainly gray areas in all of these, and if there weren't, I wouldn't have a job.
Well, yes, you would, because too many people don't really understand this. And I'm sure you've run it. I see it in my practice with small and mid-sized businesses where they really don't understand some of the nuances, and they, as you said, you've had clients that think just because they're paying them salary, they don't have to pay the overtime.
Right. So for the administrative exemption, it really has to do with, are you providing a function that's common to most businesses? So things like HR, accounting, compliance, quality control, those are the types of jobs or the departments that would fall within the administrative exemption. But even within that, you have to have a requisite degree of independent discretion and judgment on matters of significance. So it's not enough just to be in that department. You actually have to have some real clout or some real authority.
So it's which makes you a supervisor or of a department or someone that actually has decision making responsibility or supervisory responsibility.
Right. So for supervisors, they would probably fall under the executive exemption, which generally requires you to be supervising at least 2 or more full-time employees. Now, even there, there's gray area as to what it means to actually be supervising. And there's all sorts of different factors that go into that task, such as, do you have the authority to hire? Do you have the authority to fire? Do you discipline? Do you assign work? And you can really get into the details of something like that. So it's easy to see, and these are the simple exemptions. So it's easy to see how this can really be confusing for a business owner.
But those definitions really haven't changed much.
Correct. So what the change on December 1 affects is not the definition of the job duties, but the second component of the exemption test for these exemptions, which is the salary component. So for these 3 exemptions, the white-collar exemptions, there's always been 2 parts of the test. The first part being, do you meet the job duties? And assuming that you do, the second part of the test is, are you paid a salary of at least $455 per week? So what the change on December 1 affects is the salary component of this test.
And we'll talk about that when we come back from and what's the other thing? The salary component.
And the job duties component.
Okay. So those are the 2, and they are independent because you can be a supervisory personnel or an executive or a professional and not earning in the old law, that $455 a week.
Exactly.
But you still, and if you didn't earn that, you were still required to pay the overtime.
Correct.
Okay. We're going to take a break, first commercial break. As we do, we're going to have the traffic update. And when I come back, I'll continue my conversation with Russell Berger, lawyer and employment attorney with Offit Kurman. Later in the show, I will have the AHA Business Trivia Contest. I'm Allan Hirsh of Allan Hirsh Advisors, and this is AHA Business Radio on CBS Sports Radio, 1300 AM.
Now back to AHA Business Radio, creating aha moments for business, by business, and about business. Once again, here's your host, Allan Hirsh.
Well, welcome back to the show. I'm in the studio with Russell Berger, labor and employment attorney with Offit Kurman. We've been talking about the new guidelines and new increased minimum wages for exempt and non-exempt employees. I wouldn't say minimum wages because that would be talking about the minimum salary requirements, but we're talking about differences between exempt and non-exempt, and we were just getting to that when we had to take the break. So when we were just before leaving, you were talking about how prior to December 1st, the 455 was the number that someone had to earn to be classified. One from the wage salary was $455 a week, plus be able to qualify under the other qualifications.
Right.
And so where are we going now? And as I think you pointed out, that's what, $22,000, $23,000.
Right. It's in that neighborhood.
Yeah, and it's been around for 30 plus years, maybe.
Right. So the way the test is set up now, at least for these white collar exemptions, is you have to satisfy the job duties, which may or may not be the case, and we've talked about that. And you'd have to satisfy what's called the salary basis test, which was a guaranteed salary of at least $455 per week. Pretty much in today's world, and it probably has been this way for a long time, anybody that satisfies the job duties test is probably making at least $455 per week. So it kind of makes that second factor a non-factor. And it's effectively by inaction by the Department of Labor has kind of become a moot component of the test. So what President Obama asked the Department of Labor to do was to revisit these tests and come up with new numbers and modernize this component of the test. So effective December 1, what's going to be rolled out is the salary basis is going to jump from $455 per week to $913 per week. And that works out to $47,476 per year if you annualize that salary. So you're more than doubling this test. So the practical effect of that is presently you probably have people that are properly classified as administrative exempt employees or other types of white collar exempt employees that maybe are making $30,000, $35,000, $40,000, $45,000 per year. Their job duties aren't going to change, but unless you as a business owner give them a sizable raise up to the $913 per week, they're now going to be classified as non-exempt, which puts the business owner in a predicament where they either have to give an increase to the rate, an increase to the salary to bring them up to the over $47,000, which, if you have an exempt employee that's making $35,000, $40,000, that is a healthy raise. Or the alternative is to reclassify these employees as non-exempt employees, meaning that now you have to track every hour worked and pay time and a half on overtime.
So what are you advising your clients to do in order to, and some might be different depending upon the economic situation they find themselves in, but what are some of the businesses doing to get ready for this?
Well, I think most businesses are converting employees to non-exempt employees that were previously exempt employees. And the reason being simply, if you have someone that's $35,000, $40,000 a year and you've got to give them a $10,000 raise or track time, tracking time is not without its cost, but it's not $10,000 a year worth of cost, even if you're paying overtime. So I think unless you're close to that $913 per week. The smart move or the common move tends to be to just convert them to non-exempt employees and track their time and pay overtime and do everything that you have to do under the law for non-exempt employees.
Well, I just want to remind everybody, before I next ask a question, I want to remind everybody that I'm talking to Russell Berger of Offit Kurman, and we're talking about the new hourly wage and exempt, non-exempt status. So if you have any questions, any comments, give us a call at 410-481-1300. So if they reclassify them as non-exempt, what happens when they find out that someone making, say $40,000 is working an extra 15 hours a week? They pay time and a half. They're now being paid more than the $47,000. What kind of consequences, if any, are there if they then reclassify them again as an exempt employee and raise the salary, which means they actually may earn less money by being on salary, but not entitled to overtime? How is that going to impact, and what are companies, can they reclassify, and what kind of impact might this have on businesses?
Sure. Well, the short answer is yes, they can reclassify. I think what a prudent business owner would do is kind of run through these calculations ahead of time so that going into December 1st, the business owner has an idea as to whether or not, I'm going to be paying so much overtime that I'm going to go over the $47,000 anyway, or this person barely works overtime. They're 9 to 5. I don't have to worry about it. I can make them hourly and don't have anything to sweat. I think that's part of the calculus that, I can't really do that as the lawyer. That's something that the business owner really has to do for themselves. And I can obviously give the legal guidance, but, I don't know how often people are working and the math of it. Should just generally not ask lawyers too many math questions.
Well, that's why they have accountants, I hope.
Right.
If you were good at math, you might be an accountant.
That would have been one of my pursuits.
So what happens on December 1st, and it probably doesn't change what would have happened prior to it, but what happens December 1st if a business doesn't convert and accommodate the new law? What situations can happen to them if they don't move into the new exempt, non-exempt, and the dollar numbers required?
So let's take the example of someone who would typically satisfy the administrative exemption, satisfies it today, is making $40,000 a year. That employee on December 1st, if you do absolutely nothing, will no longer satisfy the administrative exemption test because they're no longer satisfying the salary component of that test. Once they're no longer satisfying the exempt test, they're a non-exempt employee, which means the law requires, to simplify it, two things. One, you have an obligation to track that employee's hours. Whether they're working overtime or not, you're supposed to be tracking the hours. And two, when they do work overtime, you have to pay time and a half of the regular rate, which is not necessarily the same thing as an hourly rate, but lots of times it is. But you have to pay time and a half for overtime. So, and this happens all the time, even now, where employees get misclassified as exempt and they're really not. The employee, the business owner thinks the employee is working 40 hours a week, doesn't think there's any problem, and then the employee gets terminated. Or the employee gets disgruntled for one reason or another.
The employer could think the employee is working 50 hours a week, but he's salaried, so he doesn't have to get the other time and a half. I mean, whether he's tracking it or not tracking it, there's that misconception there.
Right. And the way I see it typically is a lawsuit gets filed, and whenever a lawsuit gets filed, they always allege, I worked 60 hours a week. I worked 65 hours a week. I worked 55 hours a week. I don't think I've seen a lawsuit where they allege, well, I actually worked 43 hours a week. It was just a little bit of overtime. It's always a big number. And because you've classified this person as exempt, and maybe you have some sense of when they're working based on seeing them in the office or looking at their email traffic, you don't have any timesheets. So the employee files a lawsuit and says, I worked 60 hours a week on average. and the employer says, there's no way that guy works 60 hours a week. That person was 9 to 5. They weren't here more than 40 hours in a week. Well, my question then as a lawyer to the business owner is, okay, well, send me some timesheets, send me some records so that I can push back on this. And the business owner will say, well, I classified them as exempt. I don't have anything. And then it becomes my job becomes much harder at that point because it's a he said, she said type of situation. And those are winnable in the legal context. But generally, those types of cases aren't winnable unless you go all the way through to a trial, which means as a business owner, you probably have already lost because you've spent a lot of money to get there. In contrast to that,
well, you probably, if somebody, you probably spent more money on attorney fees to get to trial than you would have spent just paying him agreeing to his overtime hours and paying him,
right,
and trying to settle it,
right.
Because the only one that really wins in lawsuits are the attorneys. But that's
I would agree with that. I mean, I'd if my clients were all calling me ahead of time to do compliance work and keep them out of trouble, I think everyone would be much happier, myself included.
That's one of the reasons I do these shows, so business owners understand some of the things they need to do. This is a great time to take a break, go to the next commercial break. And when we come back, I will continue the discussion with Russell Berger, labor and employment attorney with Offit Kurman. And later in the show, I'll have the AHA Business Trivia Contest. I'm Allan Hirsh, and this is AHA Business Radio on CBS Sports Radio, 1300 AM.
Now back to AHA Business Radio, creating aha moments for business, by business, and about business. Once again, here's your host, Allan Hirsh.
Welcome back to the show. I'm in the studio with Russell Berger of Offit and Kurman. He's a labor and employment attorney. We've been talking about the new exempt, non-exempt status requirements set up by the Department of Labor. If you have any questions or comments, please give us a call at 410-481-1300. So we were talking about some of the advice to give clients and what happens when they don't comply. So you were talking about that before we went to the break. So why don't we finish that, and then I have a couple more questions on this before we go to a couple topics.
Sure. So, and this happens whether you make the change on December 1 or you've just misclassified someone already. But generally what happens is if you misclassify someone, you don't track their time. They come in when they file a lawsuit and they say, I worked all these hours, and you don't have evidence to push back on them. So you have to go through the whole process of trying a case to see who's more credible. And that's costly, and you may or may not win. And because you didn't track time like you were supposed to, you're already kind of behind the eight ball. So what happens in these lawsuits is a couple things. First off, these cases have become class actions very easily. It's not just the typical class action procedure that everyone's heard of and as a business owner should be afraid of to some extent. But there's an even lower bar under the FLSA that allows notices.
The Fair Labor Standards Act.
Correct. So there's a process called conditional certification by which basically anybody who's in this class, similarly situated to the plaintiff, will receive a notice inviting them to join the lawsuit, and they have to affirmatively.
So if you fired that one employee and he's filed a lawsuit to get overtime, everybody else who's working for you working for the business gets a notice saying that someone has filed this claim. In the
same job classification.
Okay.
So let's say there's 50 people that fall into this job classification. Notices would go out to all 50 of them. Generally speaking, 20% to a third will actually join the case. So let's say it's 15 people join the case. So now you've gone from one person to 15 people suing you. And let's say the average claim of unpaid wage might be worth $5,000. So one person, with respect to one claimant, that's not that big of a number. But when you multiply it by 15, it becomes $75,000.
You actually do know some math.
Just FLSA math.
Okay, very basic math. Okay.
That number under the FLSA can be doubled. So, and this is, I think, easy math. That becomes $150,000. It can also, under the Maryland laws, it can be tripled. So it could become
225.
Thank you. 225,000. And on top of all that, the plaintiff's lawyer is going to get his fees even if there's a nominal recovery. So, it could cost $50, $100, $200,000 worth of plaintiff's lawyer time to get to that $225,000 recovery.
If you just sat down with the person, paid him worked out in negotiations for the $5,000 or $10,000 that he claimed you owed, you're sometimes better off.
Yeah, I mean, you'd almost certainly will always be better off dealing with one plaintiff as opposed to a class of any magnitude because it just multiplies exponentially.
So I'll ask a question, and maybe it's self-evident. Trying to understand this and not knowing whether someone would really be classified or not classified, would it behoove a business when there's anybody that you're in a risk management type of situation, when you have anybody that you're not sure of whether they're exempt or non-exempt, you've classified them exempt, to actually track their hours as if they were hourly but paying them a salary? Is that something that you recommend businesses do?
I think the first piece of advice would be to get the classification correct. But if you are in a gray area or you're taking a risk, I think it does make sense to track hours, even for people that you're classifying as exempt, because it at least gives you some ability to push back, where you can say, look, this person, we classified them as exempt, and if we go to court, we're going to argue that this person was exempt, and we may or may not win that argument. But if we lose that argument, we've got a backup defense, which is this person didn't work the 60 hours that they're claiming. We've made them log hours. We can show that they only worked 45 hours, and that might take that $5,000 claim and shrink it down to a $2,000 claim. Right.
Or their $20,000 claim down to $5,000 or whatever it is.
Right.
One other question that I have on here, and I'm going to get to that right after this, just to remind everybody, if you have any questions for Russell or me, please give us a call, 410-481-1300. You mentioned something in the break that I hadn't thought about, which is which hasn't changed, which is measuring the overtime. A lot of businesses pay every 2 weeks.
Right.
So you were talking about it. Why don't you explain to the audience what that bit about the 80 hours versus 2 40-hour weeks, even if you pay every other week?
Right. So lots of times what happens is employers will pay their employees biweekly. So in doing that, lots of times the way hours get tracked are based on 80 hours in the pay period. So some employers will pay overtime once you hit 80 hours in a pay period. Now, the problem with that is the law looks at overtime on not a pay period basis, but a weekly basis. So you could have a pay period where someone worked 80 hours, but it might be 50 hours in week 1 and 30 hours in week 2. And if you don't pay the 10 hours of overtime from week 1 as overtime, you're not compliant with the law.
So basically, you can't have someone work extra time and give them time off in exchange for that. So you can't swap their time an hourly if they're a non-exempt employee.
You could do that, but limited to the same work week.
Same work week. So you can't do it and give them an extra couple days vacation in a month.
Right. So if you have somebody who works 10 hours on Monday and 10 hours on Tuesday, you can tell them to go home on early on Friday, so you limit them to 40 hours in the week. But if they work 50 hours in week 1, you can't say just take next Friday off. You've got your 80 for the pay period. That's not how it works.
Okay. Well, that is very interesting, and I think it's important for the listeners to know, both employees and employers that are out there listening. I want to take it to a little different subject, which I hope doesn't take too long. But the state of Maryland just recently, and I think it went into effect October 1st, passed I guess it's a revised law on equal pay for men and women.
Right.
Can you talk about what that change was, if there really is a major change, and what both employees and employers should be looking at regarding this new change in the law?
Well, I think the most general way to look at it is that as an employer, you shouldn't be paying someone differently based on their gender. And I think that's been the law for a long time. I don't think that's, there's anything new about that. I just think this is a renewed focus on the issue because, despite the equal rights movements, primarily in the 70s, and the changes in the laws that were enacted then, there's still a pay gap. And so this law is aimed at trying to ameliorate that pay gap between men and women. And there's a whole bunch of reasons why that pay gap may exist. But the idea of the law is that no matter what, moving forward, that gap is not going to exist because employers are making not just a conscious decision to pay women less than men, but are doing things that cause that to be in effect.
So what kind of things would that employers might be doing to whether consciously or unconsciously, doing to cause that kind of a inequality in pay?
Well, I think one of the things that comes up a lot of the time is that the policies that an employer has in place are counterproductive to women in the workplace. And if you know anyone who's had a child and is still trying to work, you know how challenging that can be. And sometimes employers don't have policies in place to properly address the issues that a working mother is going to have. So, while there's still a law that addresses nursing mothers and giving them time to nurse and providing a private place for them to pump, I think a lot of times employers don't really think about those issues and how it affects a working mother. And I think one of the things that employers should focus on, especially now in light of the renewed focus on this law and the revisions to this law, is taking steps to address those issues and making sure that it doesn't affect the actual production and standing in the workplace. So, for example, if you're in a sales position and you have less ability to conduct sales because you're coming back from a pregnancy, or you missed time because you were out on FMLA leave, these are things that employers have to take into account when they're awarding bonuses and raises and how that tracks moving forward.
And I'll say something quickly. This is also something that needs to be, when you think about it, and I would think you would agree that it needs to be discussed in a employee handbook so that everybody understands, including the owner, who's responsible, what the responsibilities are of the business to the employees, and the responsibility of the employees to the business.
Yeah, I think this certainly belongs in a handbook, as do pretty much anything we could possibly talk about during this hour. It probably belongs in a handbook, and our general recommendation is that every year to 2 years you take a look at your handbook and update it, because laws change.
Well, we're gonna, in the next segment, we're gonna talk about one of those recent changes. So let's go to the next commercial break. We come back, I will have the AHA Business Trivia Contest, and I'll continue my discussion with Russell Berger. I'm Allan Hirsh of Allan Hirsh Advisors, and this is AHA Business Radio on CBS Sports Radio, 1300 AM.
And now it's time for tonight's AHA Trivia Question, where you can win great prizes from the AHA Business Radio Show. Call 410-481-1300 if you know the answer. And now, with tonight's AHA Trivia Question, here's your host, Allan Hirsh.
Welcome back. Tonight's trivia question, if you've been listening to the show, you should be able to answer this. What is the new minimum weekly or annual salary, I'll take either one, to qualify as an exempt white-collar employee as of December 1st, 2016? So the first caller with the correct answer will receive a gift certificate to the 1010 American Bistro, a member of the Bagby Restaurant Group here in Baltimore. Again, that's 410-481-1300. So please give us a call if you've been listening, or if you want to look it up, give us a call with the new salary, annual, weekly, or minimum weekly or annual salary to qualify as an exempt employee. We had to give you this gift certificate. So, Russell, before we went to the break, and just remind everybody, Russell Berger is in the studio with me. We've been talking about employment law. Recently, the National Labor Relations Board made a ruling on social media, which many, and we talked about handbooks, which reminded me of this, that I wanted to cover it. As I understand it, it changed the way businesses have been, in many ways, putting the requirements and the restrictions in their handbooks or trying to control their employees on social media. So can you explain a little bit about this new change?
Sure. So what the NLRB protects, or what they enforce a law called the National Labor Relations Act. And what the pertinent part of the National Labor Relations Act protects employees who are engaged in protected concerted activity. And concerted activity could be lots of things, right? It could be two employees talking to each other about their working conditions. It could be an employee protesting outside, or employees protesting outside of the place of work. But
part of this is the NLRB's efforts to allow workers to try to talk about their job and try to organize.
Correct. So the main thrust of the law and what the NLRB's role has historically been is to protect unions and allow employees to form unions and prevent employers from engaging in unlawful means to prevent unions from being formed. Now, what has happened more recently, especially under the current administration, is that the NLRB has gotten a little bit more aggressive, and that might be an understatement, but they've gotten more aggressive, and they've started poking their nose into things where they maybe historically haven't played as big a role. And one of those areas, obviously, is social media, because it didn't exist previously. But what they're doing now is they're addressing it in these issues in non-union workplaces, which again, it's always kind of been what they've been allowed to do, but they're doing it more aggressively, and they're asserting themselves more now. And so what they've done with respect to social media is there's a relatively recent case where an employee posted on Facebook some very negative comments about his boss. And the employee got terminated as a result of these comments. And what the NLRB had to say about it was, you can't terminate an employee for this, because this can be protected concerted activity, because this is an employee engaging in a dialogue with potentially fellow employees who are friends on Facebook, could like the post, could comment on the post about the terms and conditions of the work environment. And so, that kind of set off a series of modifications to social media policies that employers have. And there's still ways to control. There's ways to require disclaimers. There's some different things that you can do as an employer to try to curtail or limit some of the impact that social media can have. Because obviously, as an employer, you don't want your employees out there on the internet bad-mouthing your company. But it's not. The point is that now you have to do it in a little bit more of a cautious manner, because things like this are out there, things like this decision. And that's not to say that it's every judge everywhere is going to agree with that standard, but that's out there, and that's something that employers have to deal with.
I just want to remind everybody, we do have the trivia contest going on. What's the new minimum weekly or annual salary to qualify as an exempt white-collar employee as of December 1st, 2016? Please give us a call at 410-481-1300 if you think you know the answer. But from a employee point of view, the old kind of stuff was really relegated to the shop, to the office, the communications.
Right.
Social media has changed it from a business point of view to the point that anybody can see it, basically. You put it on Facebook, you put it on and your comments can go anywhere. You can put it on Yelp, talking about, and the issue from a business point of view, as a previous business owner, is that you don't want what's going on inside your business communicated to the public. But the NLRB, as I understand, is ruling that because so many people are using social media, that's now how people communicate. I mean, you go into a restaurant, you'll say two people having dinner together, and they might be texting each other because they don't want to talk to each other.
Right.
And that's how today. That's how people are communicating.
Right. Right. I think this is true a lot of times in the law. And, we were talking about the FLSA, the Fair Labor Standards Act earlier, and there's an exemption under that law called the computer professional exemption. And the short version of that is if you're designing a computer system and you're doing the engineering and design, just building a whole system, that's exempt work. If you're the help desk, it's not exempt work. But the problem with that law is it's going to courts where it's being interpreted by judges who, like most lawyers, don't really understand a whole lot about technology and need lots of help in those areas.
Well, the internet's only been around 25 years and 3 months, so it's not been that long. And most of the judges have went through college. It didn't exist.
Right. So you end up with people deciding issues about what is permitted under the National Labor Relations Act on social media, or who is an exempt employee in the computer engineering arena, who don't really understand these things.
But unfortunately, that's what's happening as businesses, unless a higher court overturns those things, they become the practice of which all the businesses out there have to think about trying to adhere to.
Right. And it's easy for me to say because I'm the lawyer and not the business owner, but that's why I had to proceed with extreme caution when you're into these gray areas.
So is there anything else, anything else new that the listeners should know about with regard to business practices, restrictions, and changes? I read somewhere, and I don't know if it's true, that there's something to do with non-compete, and there's a change in that area very briefly.
Well, with respect to non-competes, they're generally enforceable in the state of Maryland, but the standard of enforceability is one of reasonableness. And I always tell clients, what's reasonable in any given situation depends on the judge you have, what they had for breakfast that morning, what kind of mood they're in when they're hearing your case. And that's a very hard thing to account for. So, I'm generally an advocate of clients coming up with narrowly tailored non-competes and other types of restrictive covenants to limit their exposure.
Okay, so just before we go, just want to remind everybody that the trivia question, it's a little bit too late unless someone's dialing right this minute and can get to Nathan before I finish the question. What is the new minimum weekly or annual salary to qualify as an exempt white-collar employee as of December 1st, 2016? If you'd listened to the show, we talked about it earlier. The new level is $913 per week, or $47,476 per year salary. Any last comments, anything that you think is important before we close up the show?
I think my general point to all business owners and employers out there is you've got employees and you might have great relationships with them now, but at some point, a lot of them are going to become former employees. And, you might think you can get away with some informal practices because everyone likes everyone right now. But the second an employee decides they don't like you anymore, if you haven't been following the law and ensuring compliance, you've got a lot of potential exposure.
Yeah. So it really behooves you to understand what you're doing and try to do it within the law and mitigate any kind of risks that you have.
Absolutely.
Anyway, Russell, thank you very much for being here. How can any listeners who is interested in contacting you about anything we discussed or anything else with labor or employment law, how can they reach you?
Sure. My office phone number is 410-209-6449. And you can also find me on my firm's website. That's www.offitkurman.com, and that's spelled OFFITKURMAN.
Well, again, I want to thank you very much for being on the show. I want to thank my producer, Nathan. I want to thank videographer, Larry Wilner, for videotaping the show. He's with LW BizFlix. Please join me next Tuesday at 6 p.m. My guests will be from the Maryland Chamber of Commerce, the new president, Christine Ross, and the chair, Sheila Murthy. And we'll be talking about the changes happening at the Maryland Chamber of Commerce. I'm Allan Hirsh of Allan Hirsh Advisors, your host. To reach me, call 443-986-0000. 977-4500. This has been AHA Business Radio.